They certainly could have amended their documents. But no, they decided to come to General Assembly. It's easier to convince 51 of us versus convincing 66% of their citizens. I know you've all heard about the whole long story about Grandma that still exists. They can still nail her for her Christmas lights. And if you're going to hear again about no, it's fixed, well, we heard that last time. Obviously, it wasn't fixed. I urge you to vote against this bill. You're not voting against an amendment. This is your choice of voting for the citizens or the HOA associations. Thank you.
Gentleman from Salem, Delegate Lee.
Mr. Speaker, speaking of the amendment. The Speaker, members body, that's the exact same argument that was made 6 weeks ago and that 80 plus of you all voted against. Let me explain what this bill is. Remember, this is the HOA bill that a lot of us opposed all the way through. I voted against it every single step of the way until the conference report. What the conference report did, and it's so important for homeowners, is if a homeowner wins in litigation against the association, for the first time ever, the homeowner gets attorney's fees. That is a big prohibition against frivolous lawsuits from a homeowner. The prevailing party now gets attorney's fees. That's the balance with the general's report. So it started off as a bad bill. It was a terrible bill. I agree. The conference report that Delegate Sorrell, Senator Peterson, myself, Delegate Lundy worked on fixed the bill that we all voted against. Many of us on the conference committee. It became a good bill. This is simply a technical change. What we're voting on today simply takes one sentence and moves it down to a later place in the bill. It was referenced in the wrong place. Technical change. For the 82 of you voted for before, you can vote for it again, and you should accept the governor's amendment.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk, close roll.
74 noes 19.
74 ayes, nays 19. The bill, the governor's amendment is accepted.
Turning to page 11 of the calendar, House Bill 829, Act of Amendment Act of Protection of Generally, the use of automated sales suppression devices nowadays. Passed the House February 11th, Congress authorized the House of March 3rd. Governor's recommendation is for law.
Gentleman from Fairfax, Delegate King.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I'm going to ask you to accept this amendment, and I'll just explain briefly. This is a bill that would outlaw the use of software or any other device that help you with cheating on sales taxes. Obviously, it's already illegal to be cheating on sales taxes by a retailer or any other level at the state and local level. When we worked on this bill through the course committee, we made some changes to make sure that we clarify what this new crime would be and what it would not be. As part of the conference report, we added some language to clarify where the once you have a civil penalty as part of the penalties. So unfortunately, we didn't clarify enough. So if you collect sales taxes that were issued upon that was a state portion, that state tax ought to come out of the state general fund. But it was local, and the local amount should go to the local government. So that's what this number will do, is clarify where that funding is for local versus state. So that's the body except the governor's amendment.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk, close the roll.
94 noes 0.
94 noes 0. The amendment passes.
Continuing on page 11, House Bill 866, the bill of amendment repealing all sections of the Code of Virginia for all chapters of the Act of 1954, which provide a charter for how Christians for relating to boundaries, town council, and town office power. That's the House of 31st of January. Your recommendation is for the
Gentleman from Montgomery, Delegate Rush.
Thank you, Mr. Speaker. Mr. Speaker, ladies and gentlemen of the House, House Bill 866 updates the town charter of Christiansburg. The governor's amendment is technical in nature, and I move we accept the governor's recommendation.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk, close the roll.
93 noes 0.
93 noes 0. The governor's amendments are accepted.
Turning to page 12 of the calendar, House Bill 868, an act of amendment that section of regulating conditional release of geriatric prisoners, persons of protective orders ineligible. Passed the
is.
Thank you, Mr. Speaker. Mr. Speaker, members of the House, just to refresh everybody real quickly, House Bill 868 was legislation that was brought to me on behalf of the constituent in the city of Bradford. It would propose to expand the list of offenders who would not be eligible to petition for conditional release if they were convicted of a felony or acts of violence and were subject to a protective order at that time. This bill has been a bipartisan effort between me and Senator Puckett. It passed out of the body in 1962 and on the Senate 40 done. The governor proposed several recommendations to the bill that I'll speak about, and I'll ask the body to reject them. The first recommendation eliminates all the stalking and family abuse protective orders, and now only applies to protective orders issued under subsection 16.1-253 of the Code of Virginia. This particular protective order only deals with children. It would not apply to the instance that this lady brought the bill to me. The second, so it would actually gut the entire purpose of the legislation. The second amendment eliminates the nexus between the protective order and the felony act of violence. Under my bill as passed, the person protected under the order must be the victim of the violent felony in order to trigger the denial of geriatric parole. Now, so long as the protective order exists and the violent felony is committed, the offender is ineligible for geriatric parole. An example could be given that the person was subject to a child protective order required to access a complete stranger's car would be ineligible for that geriatric parole, even though the protective order wasn't for that particular person. And lastly, one that I think is pretty far-reaching in and of itself. The amendment provides, one of the recommendations, third recommendation provides that the prohibition on geriatric parole does not apply to persons who are serving life sentences for non-homicide crimes committed while under the age of 18. This amendment seems to be trying to address a pair of recent Supreme Court opinions in Graham versus Florida and Miller v. Alabama, which prohibit mandatory life sentences with no chance for release for juvenile offenders. While the governor's amendment seems consistent with these Supreme Court opinions, I believe it is better left for a comprehensive solution to move through the committee process, one that involves prosecutors, defense attorneys, law enforcement, and our own courts committee in the House to craft that solution. So, with that, I would put the House to reject the governor's recommendation.
Gentleman from Fairfax, Dr. Sorrell.
Speak to the amendments, Mr. Speaker.
Gentleman from Florida.
Ladies and gentlemen, this bill, albeit well-intentioned, I think it had a lot of consequences to it, which nobody realized when this passed. And I appreciate the gentleman and the senator's motivations. The legislation passed is really destructive of a lot of policies in the Commonwealth, and diverse divided votes supported the governor's amendments. First of all, just so everybody understands how the system works today. We abolished parole, I guess, back in mid-90s under Governor Allen, I want to say like 94, 95, something like that. However, we left in the code that a prisoner was entitled to petition for geriatric release if they were 65 years or older and had served 5 years of their sentence, or they were 60 or older and had served 10 years of their sentence. And every prisoner who would like to seek parole, the parole board has to conduct an inquiry. And they have to evaluate the inmate's potential threat to the community. Then they have to decide whether to release that person to be a threat or not. My understanding, and gentlemen, correct me if I'm wrong, about the individual who brought this to the senator's attention, is that the situation occurred between her and another individual who's currently incarcerated. And for the last few years, he's come up for parole. And every year, in accordance with the Department's regulations, the Department of Prisons sends the victim of the crime a notice that this individual is up for parole. We're just letting you know. And every year, the Department of Parole has looked at this guy. They said, you're staying in jail. And they haven't let him out. So the system is working. I think the constituent reference is worried that maybe one day he'll get out. But so far he hasn't, because the system is working. Because they consider the facts, they consider his history, and they looked at how he behaves as a prisoner, and they won't let him out. Now what the bill does is drafted, and the reason it's destructive is because what it does is it almost merely gives the keys to the prison to the crime of the victim, decades after that person has served their time. If you read the bill carefully, I'm going to go through the amendments, the governor's amendments one at a time, so the body understands exactly what they did. I think the gentleman was a little too general in describing what they did. First of all, the governor's first amendment deals with lines 10 and 11. If you read lines 10 and 11, what the bill says is that if somebody is subject to a protective order related to a victim, at the same time they're convicted of a felony related to that victim, they can't get geriatric parole. What lines 10 and 11 say is that if you read this language, it also says that you can get a protective order after you've been convicted. The current bill says, or after the offense or prior to being released. So in other words, right now, if we pass this bill, if somebody's in jail, they serve for 10 or 20 years, somebody can go to a magistrate, they go to a juvenile court judge, they go to a general district court judge, they can make an unsworn, they can make a sworn allegation against somebody that's never litigated. The person in jail has no opportunity to present their side of the case to her and say, this person is threatening me from jail, they're saying they're going to get out. The person will go to a judge and say that, the judge will issue a protective order on the spot. That person is barred from geriatric release for life, based on an untested, unlitigated allegation, the way this bill is currently written. What the First Amendment does is it takes away that language that says a protective order issued after a person has been incarcerated. First Amendment is an excellent amendment because it prevents the victim from sort of hijacking the parole process. Number two, the Second Amendment, if you read, deals with lines 12 through 14. If you read that section, it lists 1, 2, 3, 4, 5, 6, 7, 8 different code sections of protective orders that would bar somebody from geriatric parole. This limits it to one. That is a protective order involving a child. So what this says is, if Amendment number 2 passes, is that the only protective order that prohibits you from geriatric parole is a protective order relating to a threat against a child. It narrows it down. The other kinds of protective orders the gentleman did not mention that would bar somebody from parole, like boyfriends and girlfriends. You all might remember, like 2 years ago, we passed legislation broadening protective orders, saying that non-family members could seek protective orders against each other. That kind of protective order will qualify with this. This narrows it down to just protective orders involving children, which is an appropriate amendment to limit the scope of this. The Third Amendment deals with the constitutional problem. In 2012, the United States Supreme Court held 2 different cases, Miller, Alabama, and Jackson versus Hobbs, that it violates the United States Constitution's prohibition on cruel and unusual punishment to sentence a juvenile to life in prison without possibility of parole. That is unconstitutional today in the United States of America. And what this bill does is we don't have an exception for juveniles, and we're passing a law that's unconstitutional the second it passes. And Mr. Speaker, we shouldn't be passing laws that are unconstitutional the second we pass them. We shouldn't be going to the courts to figure it out after we pass them. We know they're unconstitutional. Now, if there's any concern, this bill does not take away a parole board's discretion. These amendments do not take away the parole board's discretion to keep somebody incarcerated. The parole board still has the discretion to keep somebody incarcerated if they think them as being a threat. But if this bill passes without these governor's amendments, it could potentially have the impact of basically completely abolishing parole in the state of Virginia. Mr. Speaker, that is not a policy that we thought we were enacting when this bill passed. It did pass this body in 1992. When the Senate bill came through, it was actually, I think, there were 14 votes against it, as people started to figure out the full impact of this bill. But we should not pass a bill that's unconstitutional that changes parole policy radically simply because one person is concerned that somebody might get out when the system is working properly for that person. And this amendment narrows it way down and urges body to support the governor's amendment.
Chairwoman Fairfax, Delegate Watts.
Mr. Speaker, first I'd like to request that the amendments be severed Actually, I said all three. I had no problems with the explanations that have just been given for amendment number 1, which keeps someone from just requesting a protective order after the person has been incarcerated. Nor do I have any problems with addressing the constitutionality issue in amendment number 3. So I would urge support of both of those amendments. But amendment number 2 was not fully described in that you will note that it also strikes the language on line 13 through 14, and the victim of the felony offense was the protected person under such order. So what we have set up by this inartfully drawn amendment is a situation where if it were to pass, someone who's under a protective order involving a child commits another violent felony, and he's now barred forever from parole under this bill. And I don't think that was ever the intent to broaden it in this way. I also do have problems, I must admit, with the content of amendment number 2. On amendment number 2, while it was described that it could include the fact that we have now allowed boyfriends, girlfriends to also apply for protective orders, I bring you back to the whole reason on the bill is that this only triggers if under such a protective order an individual violently attacked the individual who sought the order. We are talking about offenses that we see in some of the obsessive situations where whether it's acid or whether it's an attack that leaves someone who's got a physical problem then for the rest of their lives, who's scarred for the rest of their lives, who was supposed to be protected under a protective order. We are talking about individuals who focused on that individual and committed a violent felony. Therefore, because number 2 is been inartfully drawn and covers the language that the victim of a felony offense was a protected person under such order, on the face of it, I would urge you to vote against amendment number 2 because it expands this bill inappropriately, while I also address the point that I think it has restricted it inappropriately.
Gentleman from Giles, so it is.
Mr. Speaker, I will let anybody else speak before. I'll just make a couple brief comments. First, I hope it be the pleasure of the body to reject each amendment separately, as we will hopefully hear shortly. But I do want to follow up on what the gentleman from Fairfax was talking about. This was an incident that was brought to me on behalf of the constituent, like I said earlier. She had become a close friend, I would say. I've gotten to know her pretty well. And the stranger happened to be her husband. It was a domestic violence situation. She was violently attacked, stabbed multiple times. And when her husband finally went to prison, she was absolutely certain that she would never have to worry about him being out to get her ever again. And then she found out about the geriatric release, which he is eligible for. And he's absolutely right. It's up to the parole board to make that decision. And he has not gotten out yet. But there's always that possibility. Every October, she gets hers. And after this bill passed on March 8th, she called me and she was almost in tears that she would not ever have to worry about coming October year after year after year. And I had to call her lady and explain to her what we were going to do. She broke down. And for those reasons, I would reject it.
Mr. Speaker.
Gentleman from the right there, Bill Morrison.
Yield for question.
Gentleman, yield for question.
One question.
Gentleman, yield for question.
Yes, Mr. Speaker. I asked him the following. What about the following scenario where this person get geriatric release and not get geriatric release? Let's say there was no protective order in place, but he committed a violent crime against her. He shot her in the head. She was brain injured and he was convicted of aggravated malicious wounding. Would that person be eligible for geriatric release?
I would respond to the gentleman saying, under current law, individuals who are eligible for geriatric release, they have reached the age of 65 or more and have served at least 5 years of their first sentence, or if they have reached the age of 60 or older and served at least 10 years of their sentence, they petition the parole board for this release. The only exception is if any inmate is convicted of a class 1 felony, which has a sentence of death or life in prison. Under the proposed legislation that was passed in the House, the enrolled field, the list of offenders who would not be eligible to petition for conditional release includes offenders convicted of any act of violence, such as murder, voluntary manslaughter, crime-related offenses, kidnapping, malicious assault, malicious bodily injury, robbery, carjacking, sexual assault, or caution, who were at the time subject to a protective order.
Speaking to the bill, Mr. Speaker.
Gentleman has the floor.
Thank you, Mr. Speaker. The answer to my question was that yes, that person would be eligible for geriatric release. But if a person had committed an unlawful wounding against his wife, beat her up, and there was a protective order in place, he would not be eligible for geriatric release. That doesn't make sense. Let's be clear, when we start talking and we give little vignettes or anecdotes, they always seem to be very egregious situations. But here's what we're going to end up doing. We're going to deny somebody geriatric release who may have served 20, 30, or more years in jail, rehabilitated himself because there was a preliminary protective order in place, secured before or after the offense. It doesn't make sense. And let's also be clear what's going to happen. Next year, somebody's going to file another piece of legislation preventing somebody from getting geriatric release because nobody has ever lost an election by being tough on crime. And the next year, there'll be something else. The parole board actually works. They consider the facts and circumstances of the offense, and they either grant parole or deny parole. By trying to tweak it, as well-intentioned as the legislation was, I think we're going down a very slippery slope. I would ask that you support the government amendments. Thank you, Mr. Speaker.
Gentleman from Whitehall, Elliott Farrell.
Speaker, motion.
Gentleman may say it. Gentleman moves to committee question. All those in favor of moving to committee questions, signify by saying aye. Aye. Those opposed, nay. The ayes have it. Committee questions moved. Over the assembly of 3 amendments, we'll vote on amendment number 1 first. Shall amendment number 1 be adopted in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 31, no 62.
Ayes 31, no 62. Amendment number 1 is rejected. Okay, next we'll vote on amendment number 2. Shall amendment number 2 be adopted in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 16, no 78.
16, no 78. Amendment number 2 is rejected. Now we'll go to amendment number 3. Shall amendment number 3 be adopted in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 31, no 63.
Ayes 31, no 63. Amendment number 3 fails to pass.
Mr. Speaker, parliamentary inquiry. I don't think anything about this, but if Governor McCauley now vetoes this bill, we don't get to consider it again instead.
I would say that it would be helpful for me with a lot of honest statements. I think a lot of people sort of know what the rules are. So here we go. Clerk is moving down.
House Bill 882, an act to amend and enact several sections of the Code of Virginia relating to alcoholic beverage control, sale of wine and cider as well as House January 22nd, agreed by the House February 21st, government recommendation.
Gentlewoman from Richmond City, Delegate Paul.
Thank you, Mr. Speaker. The governor's recommendation is basically technical. HB 82 provides that the cider be sold in a container that's federally approved for wine. The governor's amendment in the nature of substitute allows for cider to be sold in all containers allowed by federal law. So the reason for this recommendation is that the bill allows cider to be sold in wine bottles, but most cider is sold in beer bottles. The governor's substitute will allow cider with up to 7% alcohol to be sold in wine or beer bottles. Cider with more than 7% alcohol to be sold only in wine bottles. I urge that the governor's recommendation be accepted.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 93 and 0.
Ayes 93, noes 0. The amendment passes.
Continuing with the calendar, page 12, House Bill 1005, an act of amend, repeal, and reenact multiple sections of the Code of Virginia relating to health benefit plans, individual and group coverage. Passed the House January 27th. The governor's recommendation is supported by.
Mr. Speaker.
Gentleman from Carolina, Brother Laura.
Mr. Speaker, parliamentary inquiry.
Gentleman be stated.
Mr. Speaker, while the matter before us is an amendment made to substitute, but largely may make some technical changes, would the Speaker rule on the germaneness of those provisions embodied on lines 673 through lines 680, which create a new code section and a new special exception that was not a part of the underlying legislation, never been considered by either body? And further, given that it is a part of the amendment made to substitute, if this section is not germane, does it not make the entire matter before the body not germane?
Can I ask the gentleman to close on the summary? ahead of time, so I've done some research, I listened to everyone. So let me tell you how I'm going to roll. As passed by the General Assembly, HB 1105 focuses on repealing provisions of the code relating to conversion of coverage from a group policy to an individual policy. The measure also provides a certain mandate that offers do not apply to healthcare plans, contracts, or policies issued in the individual or small group market where qualified health plans offered in the Commonwealth by a healthcare carrier or a health benefit exchange. Finally, the bill deletes references to individual conversion policies, includes technical and performance changes. The governor's amendment, however, allows individuals that have lost or have health insurance and who desire to purchase health benefit plans sold or offered for sale, one through or outside of a health benefit exchange established or operating in the Commonwealth, and two, from the individual and group markets to obtain such coverage if offered by the insurer. This new code section allows access to forms of additional insurance coverage beyond the scope of HB 1005 as enrolled. The purpose of the governor's amendment is clearly not germane and not so.
Mr. Speaker. Parliamentary Group. Mr. Speaker, I ask you, would it not be true that since you have ruled that the governor's amendment, by which he was trying to allow people to renew their existing policies as opposed to losing their existing health care policies, since you have now ruled that that is not germane, the whole bill is no longer before the body. And therefore, any efforts to keep their policies are gone.
I would say the bill is still on.
Thank you.
Continuing with the calendar, page 13, House Bill 1009. An act to amend, repeal, and reenact a multitude of sections of the Code of Virginia workforce development. As the House February 11 Conference Report adopted by the House on March 8th, the governor's recommendations are now before you.
Mr. Speaker.
Joe Carolina, Mr. Roy.
Mr. Speaker, I rise to a motion. First, I would ask that we sever amendment number 4.
And the gentleman would like to sever amendment number 4.
And Ms. Speaker, once severed, I would then ask if you would rule whether the amendment number 4 is germane to the measure, given under Rule 37 of the House. No matter shall be amended for the purpose of directing or requesting a study unless authorized by unanimous consent of the members of the House.
I think clearly, I think the gentleman clearly is a violation of Rule 37. It's not properly before the House. So let's go to gentleman Delegate Byron from Bedford, who's going to explain, I think, minutes 1, 2, 3.
Thank you, Mr. Speaker, ladies and gentlemen of the House. I would ask that we accept amendments 1 through 3. This bill dealt with changes to the Virginia Workforce Council, creating a Virginia Board of Workforce Development, along with a lot of other changes that were within the Virginia Workforce Council. These amendments actually strike some language that was put in a conference report that came the last day. I was a part of this, but I've had a lot of feedback since then because we had some definitions put in place that might need to be tweaked and some additional work that needs to be done to further clarify this new role that we wanted to create with a new advisory council. So I would ask that you accept the governor's amendment so that we can continue our work on that.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 94, noes 2.
Ayes 94, noes 2. The amendment passed.
Continuing on page 13, House Bill 1053. An act to amend reenact several sections of the Code of Virginia relating to the Office of the State Secretary General, powers and duties of criminal auditors, Virginia Freedom of Information Act. As the House February 3rd, and the governor's recommendations now reported.
Gentleman from Manassas, Delegate Miller.
Thank you, Mr. Speaker. The governor's amendment is technical in nature and it lines up the language with language that relates to FOIA and other sections of the code.
Shall the bill be amended in accordance with the recommendation of the governor? Close the roll.
Ayes 97, no 0.
Ayes 97, no 0. The amendments are adopted.
Turning to page 14 of the calendar. Bill 1072. An act to amend and act of the Second Code of Virginia relating to the Personal Information Privacy Act, use of private selected information passed the House February 3rd, and the governor's recommendation is now reported.
Gentleman from Fairfax, Delegate Bull.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, House Bill 1072 has passed, ensures that information on your driver's license can't be scanned or stored except for very specific purposes. The governor's amendment is technical, simply corrects the citation for the Fair Credit Reporting Act, and that has to be accepted.
Shall the bill be amended according with the recommendation of the governor? Clerk will close the roll.
Ayes 97, no 0.
Ayes 97, no 0. The governor's amendments are adopted.
House Bill 1109, an act to amend and enact a section of the Code of Virginia relating to the Commission on Higher Education Board appointment. Member, passed the House February 11th, the governor's recommendation is now reported.
Gentleman from Fairfax, Delegate Buller.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, the purpose of this bill is to include a faculty perspective on the Commission on Higher Education Board appointments. This is a very valuable voice. Indeed, every year we recognize the best and brightest Virginia's faculty here on the House floor. The Code of Virginia already mandates certain folks sit on this commission, including former Board of Visitors members, former provosts, and university administration. To avoid a potential conflict of interest, what we had done with this bill was to have the faculty representative be a non-voting member. The governor actually prefers that everybody on the commission be of equal footing, and that everybody have a vote to make it more collegial, and so that they work together as equals. So what he's done is proposed that we address the conflict of interest issue by making this a former faculty member. This is an approach that's consistent with the rest of the bill, whereas you have former members of boards of visitors, administrative folks, and I would ask them to pass the amendment.
Gentleman from Wyden, Delegate Ramadan.
Thank you, Mr. Speaker. Rise and speak to the amendments.
Gentleman answer for.
Thank you, Mr. Speaker. Mr. Speaker, I specifically recall this bill from the subcommittee in general laws. The intent of the bill was a good intent. We worked with the gentleman from Fairfax on it. As a matter of fact, after a long debate and taking it by for a couple of weeks where we reached a final language that we all agreed on, I even co-pictured the bill. And the agreement was, and the intent of the bill, and as it passed subcommittee and then committee and this floor, was that the perspective of the current member of faculty with no voting powers, as is the tradition in most of our Board of Visitors in most of our universities. This amendment changes the intent of this bill, and it sets a precedent in education committees that doesn't exist today in any of our boards in any of our universities. With that, I strongly urge that we reject this amendment. Thank you, Mr. Speaker.
Shall the bill be amended according with the recommendation of the governor? Clerk will close the roll.
Ayes 28, no 68.
Ayes 28, noes 68. The governor's amendment fails to pass.
House Bill 1110, an act to amend and reenact
you, Mr. Speaker, ladies and gentlemen of the House. The governor has placed language that clarifies the state and local reimbursement on this bill. If you recall, this bill had to do with a school division being reimbursed by another school division when a child transferred to a licensed child caring institution or group home outside the initial child's home school division, moved into a new school division, and it provided that new school division that was providing the education would be reimbursed from the other locality, the cost of the local share. The governor's amendment clarifies some confusion about whether the state has had to provide funding in order for the localities to reimburse. And I think it clears up some confusion about whether you would have to have the state be involved in funding in the first place. There was some concern that the bill could be interpreted as saying that there would have to be no state funds appropriated in order for the home school division to be responsible for the reimbursement. So with that, I ask the body to support the language of the governor's amendment. Yes.
Shall the bill be amended in accordance with the recommendation of the governor? Clerk will close the roll.
Ayes 96, noes 1.
Ayes 96, noes 1. The amendments are accepted.
Continuing on page 15, House Bill 1191, an act of amendment to the Virginia relating to the annual report. Evaluation of effectiveness of the Young Adult Incentive Grant. House Bill 11, sent something to the Region of the House on 25th February, recommendation
The gentleman from the White Bear, Delegate Massey.
Thank you, Mr. Speaker. Mr. Speaker, notwithstanding the coming entreaties of my good friends from Arlington, I would move the governor's amendments that I would ask the House to reject the unnecessary clause.
Gentleman from Arlington, Delegate Bryant.
Thank you, Mr. Speaker. Speaking to the governor's recommendation.
Gentleman has the floor.
Thank you, Mr. Speaker. According to the Department of Planning and Budget, the Virginia Economic Development Partnership estimates that it would require $100,000 of general fund support each year to hire an additional position to collect and aggregate the data from various state agencies in order to fulfill the purposes of this bill. Accordingly, the governor has